Hello and welcome to Everyday Law TV, the show that gives you all the law you need to know. I'm your host, Attorney Robert Monahan, and today we're going to be talking about what you need to know before you see your injury attorney for the first time. Now in this show, we're assuming you've been injured and you need to see an injury attorney. And I know that it doesn't happen to everybody, and God knows I hope it doesn't happen to you in your lifetime. Before we get to actually what happens in a meeting with your injury attorney for the first time, I want to cover a topic that bothers me just a little bit. And I'll start out by talking about it by saying that a lot of times when a client comes to see me for the first time about an injury case, one of the first things they'll say is something like, well, I never expected to be seeing someone like you in my life. And it gives me a feeling like they don't really like the idea of seeing an injury attorney at all. And I think there's a lot of reasons for that. I think that people feel that they should take responsibility for whatever happens to them no matter what. So there's kind of a strong sense of responsibility, even in the Midwest. Maybe they feel that vengeance is wrong. You know, vengeance is mine, saith the Lord. And they don't feel like bringing a lawsuit against anyone ever, no matter what happens, is a good thing to do. And also, I think it has a lot to do with PR, public relations by the insurance companies, because people will often come to see me after trying to work things out with the insurance company on their own and realizing the insurance company's not being fair with me, that I went to them with good intentions and an honest heart, and the insurance company is not being fair, and I need help. And I think that's really where most clients come to see me. In fact, one of the triggers that really makes a client come to see me is they get papers from an insurance company that they don't understand, that the insurance company is asking them to sign, and in the end, they know that their interests are really not aligned with the insurance company, and they know they need some advice. So I want to say that I love being an injury lawyer. I love it. It plays to my strengths. It lets me give scope to my curiosity about different things in the world. And it gives me a kind of an opportunity in my mind to fight injustice. And when I say it plays to my strengths, I feel like I'm a communicator, I'm a storyteller, I'm a researcher, I'm hardworking, and I like helping people. So in that sense, injury work really plays to my strengths. It gives me scope for my curiosity in the sense that I like learning about things. So if someone has a fall down a staircase and I need to learn about a building code, I like doing that. To me, finding out about how things work is always very interesting. And lastly, people say they pursue justice in this kind of work. And I have to say that in my view, I don't view it as pursuing justice as much as fighting injustice. I feel like justice as a concept is a little bit abstract for me, and I don't really know how to define it. Philosophers all throughout the centuries have tried to define what justice really is. But I do feel you can define what injustice is. Injustice hits you in the gut, and you know when something's been unfair, and you know you have a really good case when you have someone who comes to see you who's just really been treated unfairly, and you can feel it in your gut. And that sense of injustice and wanting to fight the injustice is really one of the great rewards of doing injury work. Because again, a case is only good. A case is only good if someone suffered through someone else's fault and suffered badly. And that's really the heart of a case. Sort of someone did something they shouldn't have, hurting someone else, and the hurt person needs help. And that's where I come in. So what do I do? What am I after when someone comes in to see me? How am I helpful? What is my pitch to my client about what I can do for them? The first thing I tell a client is that there's two things I can do for them almost right off the bat. Really three things. One, I can research their case in a way that they can't. I can go to the scene and look for the things that I need to see, and I think I have better trained eyes because I've been doing this for 20 years than someone who's never had an injury case before in their life. So I can do the spade work and the field work and the research and find out what it is that makes their case strong. And then the second thing I can do is take that research from the field and from books and bring it to the adjuster. Now, the adjuster is the first line of defense. You don't deal with the other party in an injury case, and you don't deal with a lawyer in the first instance. The first line of defense for an insurance company is an army of insurance adjusters, of claims adjusters, and they stand between you and your recovery. And an insurance adjuster has hundreds of files on their desk, maybe 100, 150 files on their desk, and to the insurance adjuster, these files all kind of look the same. And my job as an attorney is to show the insurance adjuster what's special about this particular case, why this case should stand out, what factors on fault make this case different than the others, why the injuries here should be valued more than typical, and what makes this case special. So that's the second thing that I do. So the first thing I do is I do the field work, the spade work, to dig out why this case works, why it's a good case at all. And the second thing that I do is I try to convince the adjuster why this case is special. The last thing I do, and this is the last way I feel I'm really useful to my clients, is if I can't reach an agreement with that front line, I can always walk away from the table. And when I walk away from the table, I know what to do. I can bring the case in front of a judge, file a complaint in court, and ask the judge for justice, or to help me fight the injustice when we start out saying our case is worth this much, and the insurance adjuster comes back and says this much, and through our process of negotiation, we're not able to meet at a middle ground that's fair. What I can do as an attorney, something that an individual layperson can't do, is take the case to a judge and ask the judge to help us resolve it, or if the judge can't, ultimately bring the case in front of a jury and ask the jury to say, who's right? Are we right up here? Is the insurance company right down here? Or, is it somewhere in the middle between us? And again, I can teach the judge, I can teach the adjuster, I can teach the jury, because again, lawyers, what they do is communicate the facts. And that's probably one of the funnest things about the job, is that you get the opportunity to make a plan inside your head and make an argument inside your head, and then take what's inside your head and try and put it in the head of someone else. Whether it's the insurance adjuster, the judge, the jury, whoever's listening to you, you can take what's inside your head and inside your thoughts and try and take it and put it in their head. Kind of like Inception, the movie. You implant an idea that you came up with into someone's head so that they think, oh, they came up with it on their own. And when you do that, you use what they've already been thinking about. You don't use any concepts outside of their own thoughts. You appeal to their own sense of injustice. Have they ever been cheated? Has someone ever hurt them in a way that was not fair? Have they ever been a victim of unfairness in their life? And you appeal to that sense of injustice. And like I said, I think there's a saying that justice bakes no loaves, but a sense of injustice can really do a lot, especially for a lawyer. Hi, and welcome back to Everyday Law, the show that gives you all the law you need to know. I'm your host, attorney Robert Monahan, and we were talking a little bit about feelings that people might have before bringing a lawsuit, why I like that work, and why I think those feelings might not be justified. I think that again, a lawsuit is only good if someone else has done something wrong, if someone else has been irresponsible. Your own fault doesn't come into it. You're not at fault if you have a personal injury claim. And I think people, when they come to see me, they come to see me with a lot of guilt and a lot of trepidation about it when they have an injury case, when they've been hurt by someone else's fault. And I'd like to just take a minute again and reassure you that it's okay, that you can have an injury that's someone else's fault and be mistreated by an insurance company. And when that happens, you should see an attorney, an injury attorney that can help you. And so the point of the show today, what we are going to try and cover was what happens at that first meeting with your attorney. What should you expect from it? What documents should you bring? What documents should you expect the attorney to ask you to sign? Before you get there, you should know a little bit about what you're going to be asked to do. So the first thing I think we should talk about is what you might want to bring to a meeting with your attorney in an injury case. And if you have a police report or any kind of report at all about the incident, that's good to bring. You can describe the accident yourself to the attorney, but if you have a piece of paper, an official report, especially a traffic accident report that gives a lot of information, that's great. One key item that your attorney is going to want to know from the report, especially a traffic accident report, is who the insurance company was for the other driver. The attorney is going to have to contact that insurance company right away and make sure they know that there's a claim from that accident. So who the insurance company is really important. Another thing on a police report is who got the citation, who got the ticket. You want to make sure that if the other driver got the ticket, that you know about it and what the officer at the scene thought the ticket was for. Was it for following too closely, blowing a red light, whatever it may be? Your lawyer is going to want to know what the other driver was cited for. Another thing that you can find on a police report are witnesses. Who are the witnesses? The witnesses to an accident on a traffic report will list the name of the witness as well as their contact information and maybe even their birthday. So you know who they are, how old they are, and what their number is. So your lawyer can contact any witnesses. And the nice thing about witnesses is that they're independent. They saw it happen and they have no axe to grind in this accident. So if you have a police report or an incident report, that's a great thing to bring along to your first meeting with your injury lawyer, because that will help him tremendously in getting started. I mean, he can really hit the ground running if he has that. Another item to bring, if you have it, are your medical records. Your medical records are very important to let your lawyer know where you started off as far as your treatment goes. If you have a fracture, if you have a concussion, if you have whiplash, those will all be noted in your discharge summary, which is the documents you get when you leave the emergency room, that will tell your lawyer, again, what he's dealing with right off the bat and give him a clearer idea of how to think about your case. Also, if by the time you see your lawyer, you have medical bills, those are important things to bring too. You may not have them if you see your attorney soon after your accident, but if you do have them, bring them, because again, that can help your attorney get an idea of what is going to go on with your case. Another great thing to bring are photos, or your phone that has photos on them. These days we all have a supercomputer in our pocket, which to me is amazing, and you can document everything that happens to you. So if you're ever in an accident, even if you're not injured, make sure to take photos of your car and the other driver's car. And when you take your photos, you want kind of to, you don't want to get right up on the dent and take a picture of it. What you want is to take a wide angle view, a closer angle view, a closer angle view, and then a closer angle view, because that will give you an idea of where that dent is on the car, and it'll give you an opportunity, anybody who's looking at it, an opportunity to see exactly where it is. Because if you hop right up on the dent and take a picture, it's very hard to give it any context. The last thing I think you need to bring is your health insurance card. Your health insurance card will help your lawyer identify who your health insurance is, who your health insurance coverage is from, what your member ID is, and so on, and get the customer service number, because that becomes very important in terms of paying your medical bills from the accident. So those are the things you should bring. Now, what should you expect to have to sign when you're seeing an attorney for the first time? Well, the attorney cannot work for you until you retain him. And the way you retain him is by signing a retainer agreement. And the retainer agreement has some provisions that you should be alerted to before you sign it. One thing you should know is that when you sign a retainer agreement with your lawyer, you're giving him a lien on whatever you get from the accident from the insurance company. A lien is a claim on the settlement or judgment that you get at the end of the case. What that means is that once the insurance company is alerted of your lawyer's lien on your file, they can't just write you a check to settle it. Any check that comes to you will have your name on it and your attorney's name on it, okay? So that you won't be able to deposit that check without your attorney's consent because your attorney has a lien on it. And that lien is for 33% of your case. 33%, 1/3 of the value of your case will go to your lawyer, and that lien will be on the case and it'll come in the check. And you may be wondering, well, if my check has his name on it, how am I ever going to deposit it? Just to get ahead of ourselves just a little bit, at the end of your case, when you get your check, you will sign a limited power of attorney that will allow your attorney to endorse the check in your name and in his name. Then he will put that check in a trust account. So again, because of the lien, the check will be made from the insurance company to you, the client, and your attorney. You will sign a power of attorney for the limited purpose of letting the attorney deposit that check in the trust account. Once it's in the trust account and it clears, your attorney makes the distribution to you, to himself, and to all the other stakeholders in the case. Anybody that's still owed a bill that also has a kind of lien. So another type of lien holder in an injury case might be a hospital, a physical therapist, or a doctor who hasn't been paid. I remember the first case that I ever had in practice was a young lady who came to me after getting a check. She settled the case herself, and I think she was very proud of it because she got a very good result. She got $50,000 from the insurance company. The problem was when she got the check, it had her name on it, and it also had Blue Cross Blue Shield as the name on the check. And her bank wouldn't let her deposit it because she did not have anything from Blue Cross Blue Shield letting her endorse the check for Blue Cross Blue Shield. And the reason Blue Cross Blue Shield had their name on the check was they had paid some of the bills, and they had a healthcare lien or an insurance lien on the file because they had paid the bills. And they'd perfected their lien, and so the insurance company had to protect the interest of Blue Cross Blue Shield and put Blue Cross Blue Shield on the check. So she could not deposit it, and that lien had to be worked out with Blue Cross Blue Shield, and Blue Cross Blue Shield had to be paid some of the settlement before she could deposit that check for herself. So that's just the first thing I wanted to let you know about the contract you'll sign with your attorney. It has a lien. It has a lien provision on it that gives your attorney a claim to the proceeds of the settlement or judgment. And that's something to really be aware of because that gives your attorney some leverage at the end of the case. There's more on that, and I'll be right back. Hi, and welcome back to Everyday Law, the show that gives you all the law you need to know. Again, I'm attorney Robert Monahan, and I'm your host. While we were off the air a little bit, I was talking to my engineer, Ed Wazinski, who I have to say is just the greatest engineer ever. He does a wonderful job for me with this show, and I really appreciate it, Ed. Thank you. But we were just talking about a couple things that I wanted to clarify so that they're better understood. First of all, I said that the fee on an injury case is 33%, and that's true of a personal injury case. It's not true, however, of a workers' compensation case. A workers' compensation case is not 1/3, it's 20%. 20% of the recovery will go to the lawyer, not 1/3, and that's a statutory fee. That means that the law is in place that you can charge no more than that. It's in a statute by the legislature that in a workers' compensation case, the fee can be no more than 20%. Personal injury cases are not regulated by statute. It's just kind of like the standard industry practice that a third is the attorney's fee. Also, it's in every contract that that's subject to negotiation, to renegotiation if an appeal should happen. What an appeal would mean, though, it's rare, because what it would mean is that there's been a trial, someone alleges a mistake was made at trial, either giving the plaintiff too much or too little, and you have to try to bring it to an appellate court, hoping that the appellate court finds the mistake serious enough to overturn the lower court's finding or verdict and retry the case. So if that happens, it involves a lot more effort, a lot more time, and most attorney contracts, retainer agreements, will have a provision saying that if an appeal happens, it has to be renegotiated. The fee has to be renegotiated. Another issue, so that was about the percentage going for personal injury claims and workers' comp claims. Personal injury claims are 33%, workers' comp claims 20%. Another issue was I brought up trust accounts. Trust accounts are where you would deposit the money after settling a case. So a trust account is a special account where a lawyer puts money that's not his yet. It's not the client's money, it's not anybody's money, it's not the lawyer's money. It's in the trust account, which is like holding it while it's nobody's. It only becomes the lawyer's money when he writes a check from his trust account to himself or from the trust account to the client. Until then, it sits in the trust account and it's money held in trust for future distribution. So those are two things I wanted to talk about. We were talking about what else would be in the contract. And the first thing we talked about, again, was the lien that the lawyer has. And a lien, again, is a claim on the settlement at the end of the case. And the lien is for 33% in most personal injury claims. And you should know about that, because if you don't know about that, you can get in some trouble, okay? Another thing to know about in the contract has to deal with costs and expenses. Costs and expenses are not hospital bills. What I mean by costs and expenses are monies that come out of the attorney's pocket to prosecute the case. The monies that go to pay filing fees and deposition fees and expert fees. If you need an expert to testify in your case, he gets paid a fee for his hourly testimony. And that's money that has to be paid by someone. And at that point, nobody has that money. You don't have an award from the insurance company that the driver that hit you, so somebody's got to pay those costs. Most attorneys' contracts will say that the attorney pays those costs himself, and at the end of the case, those will come out of the share of the client. Now, you would think that the share of the client is 2/3. The attorney gets 1/3, the client gets 2/3. That is how it works in theory. But one thing I was talking about with Ed before, while we were off camera, Ed's my engineer again, was that there are other stakeholders that have liens just like the attorney, like the lady with the Blue Cross claim with Blue Cross on her check. Anyone that treats an injured person who's been injured as part of an accident can have a lien on that person's file, can have a lien on that person's settlement, as long as they notify the insurance company that's insuring the driver that hit the injured person. And when that happens, that person will be on the check too. So the way it usually works in an injury case is not 1/3 to the lawyer, 2/3 to the claimant, the injured party. It usually works 1/3 to the lawyer, 1/3 to the doctors, the hospitals, the insurance companies that paid the bills or have outstanding bills for the client, and 1/3 to the client. So really, it breaks down 1/3, 1/3, 1/3, not 1/3, 2/3. And the reason that is there's more at stake than just the attorney's fee and what goes to the client. There are other stakeholders in terms of doctors that may have outstanding bills and health insurance companies that have claims on the settlement. Another thing to know is that The lawyer cannot settle the case. Once you sign the contract, he becomes your agent, but he cannot settle the case without your consent. So you have to agree when you settle the case, and that's very important. Another thing is you have to keep the lawyer advised of your whereabouts and cooperate with the preparation of the case. I put that in all my contracts, and what that means basically is that if you move or you change your address or get a new cell phone number, that you let your lawyer know. And another thing is your lawyer cannot promise you any value of your case at the time you sign the agreement. And that's really because it's too soon in the process to know what the case is going to be worth. So I put that in all my contracts that I can't promise any value. I make no representation as to what amount will be recovered in this case. There's one more document that you'll need to sign on your first visit to your lawyer in an injury case, and that's an authorization. What happens between you and your doctor is very private, and it's protected by federal law. It's called the Health Information Privacy and Portability Act. And that law says that without the document that you're going to sign when you see your lawyer cannot see any of your medical records. It's called a HIPAA authorization, because HIPAA is that federal law, the Health Insurance Privacy and Portability Act. So your lawyer will ask you to sign a retainer agreement, and he'll ask you to sign a HIPAA authorization, and that will let him see your medical records, which he needs to work up your case. So once again, the first time you see your lawyer, you're going to bring as much as you can when you go to see him. You're going to bring a police report or an incident report, any medical records that you might have, any medical bills, any photos, and your health insurance card so that the lawyer can get a good start. Then when you're there in the office, your lawyer will ask you to sign 2 documents, a contract and a HIPAA authorization. That will get you started. I just want to end by saying I love my job. I think I've said it before. It gives me an opportunity to help people. It gives me an opportunity to work with my curiosity. It gives me a chance to, like I said, fight injustice, which I always find really exciting. I hope you never have an injury case, but if you do, I hope this episode has given you some idea of how you should prepare for your first meeting with your injury lawyer. Everybody, please have a good night, and thanks for watching. Again, I'm Bob Monahan. I'm an attorney. You've been watching Everyday Law TV, the show that gives you all the law you need to know. Thanks again.